And that's how the market would value a property impacted by an easement. One way to look at the nature of the scope of the farm is the risk of explosion of such a pipeline. And there have been studies done taking a look at what is the area of risk, sometimes called BLAST, B-L-A-S-T zone. And that's found in the pipeline safety book. If you want to open up to the middle of the book, you're going to see a chart on the left-hand side that has pipe diameter. And you'll see around the middle of that chart, bottom to top, you have an 18-inch and a 24-inch pipeline. Well, in between there is our 20-inch pipeline. I don't know what the proposed pressure per square inch is, but let's say it's around the middle of this chart here, of around 1,000 or 1,100 pounds per square inch.
1480.
1480? That's it?
Yeah.
Okay. So that's right up near the top of the scale on this chart. So if it's 1480 and we have a 20-inch pipeline, I read a radius of the blast zone as being around 500 feet. So that the radius tells us that that would be on one side of the pipeline. If there were to be an explosion, it would end out and essentially incinerate things for 500 feet. So on both sides would be a total of about 1,000 feet. So if you've got 1,000 feet of your property within this blast zone, you've got some significant damages. Not that they want to admit that to you, not that they want to pay that for you, but you have that damage to your real estate. And this time of negotiations or litigating your property rights is when you get the recovery for it. You might not realize the harm from an accounting perspective until 20 years later when the property passes to someone else. But this would be the time to get your recovery. This is when the property is harmed. The book also has a depiction on the right-hand side of a neighborhood, the pipeline running through it, and the impact of the black zone. In contrast, what I see commonly, and is again, fairly common eminent domain of use, we see offers from property owners that don't even try to value the damages in the right way. And I see that daily in my representation of many of the property owners along the Atlantic Sunrise proposed pipeline at Williams Company. Essentially running from around Williamsport down through Lebanon and Lancaster counties down towards the Chesapeake Bay. They're presenting my clients with offers all the time that list a value per acre, let's say $20,000 per acre. And they calculate the amount of land needed for their pipeline. And there's a figure for that. And then there's a temporary construction easement, perhaps 25 feet wide, and they'll offer about 25% for that. And they might throw in some other little damages. So, and maybe for timber or this or for that. But they're trying to tell you that, hey, we can be a little generous on this price per acre here. It really is only $15,000, and we've gotten all the way up to $20,000. But they're trying to just pay for the strip, whereas the law is explicit and clear. It's a before minus after analysis that encompasses your harm to the entire property interest. So if you see such an offer presented to you, you know, and you have the proof right in front of you of them trying to deceive you and steal your property rights. So the law provides you good protection. Unfortunately, you're going to need to hire an experienced attorney to help you protect those rights. When we talk about highest and best use of the property, as we're in this area, some of the homes, some of the properties that are going to be crossed are going to be, nice residential neighborhoods. The pipelines try to avoid neighborhoods. They try to avoid commercial properties, but sometimes they can, sometimes they can't. The typical property might be a farm property that they're crossing through, and might have some concerns with fencing and animals. But note as we talk to some of the land agents about this, they might minimize your property value. Well, it's just farm property, or it's wooded. We've looked at that kind of land around here, and it's just not worth much. We're offering more than you're going to get. Well, that's not what the eminent domain does. Again, the law controls, and the law gives you rights. The law looks at property not necessarily only for the current use, but for the highest and best use. If your property might be used as a farm, but it's worth $1 million because it's a great place for residential development, a great location, it's on the edge of growing development, your property would be valued by that highest and best or different use rather than the actual use. So be aware that your current use does not limit you for the value of recovery as we look at the possibility of proving your damages. How do we prove your damages if we get to a fight? Most of the pipeline cases, I said, we don't go to a lot of litigation because the pipeline companies knows that this is what I do and I can make them pay, and sometimes pay a lot of money. So they don't want to take that risk or spend a lot of the money on litigation. There's some very good lawyers that I've litigated against. But they don't want to be fighting against each one of you in court all the time. They know that they're giving the lowball offers to begin with. And they know that some of my arguments and potential proof of harms are valid. So we would typically negotiate easement terms and compensation and settle the matters. What happens if we don't? If we don't settle the matters, if they come and condemn your property, we can settle it before or after condemnation. But if they come and condemn your property, they would file the documents that take the property from you. They file it in court. Could be county court, could be our state system in a county court, or it could be in the federal system. But they would file documents in state court, and I think UGI would generally use the state court. They would file a document called the Declaration of Taking, and go to the courthouse where your property is located and file that in court. They won't even tell you until later. So they took your property, but they didn't even tell you. They've got to tell you within 20 days thereafter, but they'll file and take your property rights away from you without even telling you. From there, they would have to pay estimated just compensation to get possession and the right to build the pipeline. If they don't do that, then they don't get possession. If they pay the just compensation, it's generally a low figure, and then we can contest it. If you don't settle the matter, I would file a petition for a board of view with the county courthouse. The local judge, sometimes the presiding judge of that jurisdiction, would appoint a board of view, B-I-E-W. For the Pennsylvania Eminent Domain Code, the board is comprised of the local attorney and 2 other members of the community. And they decide together and sit and determine the harm to the property. By the example that I had before, we might have, they might present a real estate expert that says $10,000 in damages. We might have a real estate expert that we've hired and done a written appraisal report and says $150,000 in damages. The board might be inclined towards the middle. They like the midpoint, give something to either side so that we don't get a great number of appeals that then clog up the courthouse and have a lot of jury trials. So the board of view are designed to be a kind of an administrative court and an informal and practical group that looks at value and figures out who has the better argument. When we go to a board of view trial, and I've handled a lot of them, and I've handled a lot of eminent domain jury trials, the board of view, generally we would have a real estate expert on either side, and that's the main contest, the battle of the experts. The owner can testify, and often I would use an owner to testify for certain parts of the land or features of the property and an opinion of value. Often that opinion might stretch the upper limit of the opinions that we offer for the board to consider. Appeals from a board of view, where do they go? They go to the county courthouse. Either side can appeal a decision from a board of view, and there does not need to be any error or mistake by that board. Just as a matter of right, you could go to the county court and we might well request a jury trial and have the matter heard by the jury. Usually we don't get it. Last year, all of my pipeline cases settled. I didn't have any jury trials last year. The year before, I had 4 jury trials. So they happen, but in pipeline cases, more so than other cases, we commonly get to a resolution of that. For some of you, your position in thinking is, this is my property and they shouldn't be here, and make them go around. I can try to make them go around, but I don't want to give you a lot of hope for them. One of my property owners in Washington County last year said, make them go around, Mike. The property come down from the father to siblings, 4 siblings. 2 lived there at homes. The father's wishes was subdivide this, you 4 siblings live here in peace forever on this property, and we have our little family compound. And that's what they wanted, above all else. So, Sunoco Pipeline came and offered money. I said, no, go away, they don't want you. Go away. They came back, more money, no, go away. Finally, they got the message, and they went away. They didn't come onto that land. So they could still subdivide it and have their 4 homes on it. Unfortunately, the pipeline still harmed their property. If this bingo sheet is their tract of land, pipeline came up to it, turned, went alongside it, went over, and then continued on its merry way. In that scenario, it didn't touch their property, it was right next to it. So they had the harm and the risk and the stigma and the devaluation of being right next to a pipeline without the property rights of recovery. You don't have property rights for a pipeline that's close to your property, only if there's a property right, permanent or temporary, that touches your land. So I usually advise my clients that it's not necessarily a wise fight to try to make them go around. Usually it's futile. But even if it does work, it's not necessarily the best outcome. In that outcome, I was able to force Sunoco Pipeline to pay their attorney fees and all their costs because Sunoco Pipeline didn't have the power of eminent domain. They shouldn't have even filed the documents. So the law allowed me to recover against them and help them with that part of it. But they still had the pipeline right next to their property. It's unfortunate. I feel for you, good people here on this beautiful evening, having to be here and deal with this threat of eminent domain and the eminent domain abuse that's facing you. It shouldn't be, but the way the law is unfolded has allowed this to occur. Okay, I've been talking for quite a while, and I think I've covered the major highlights here. My major message is to protect your rights. They're valuable, they're important, they're constitutionally protected. There's a Professor Eby out of Vanderbilt University who has looked at our Bill of Rights and all our other rights of our American existence. And he's described this Fifth Amendment right of personal property ownership as our foundational right of our American existence. That's what's threatened here, and it shouldn't be. So protect yourself, don't let them abuse you. So I encourage you, you have my information if you want to contact me. You might talk initially with Sarah. I'm happy to talk, happy to answer questions here, happy to talk with somebody afterwards, call my office, be happy to come visit your property, see what your problems is, see what your interest is, and see if you'd like me to represent you and protect your interests. Yes, sir.
Thank you, sir, for your presentation.
Thank you.
About 2 months ago, and we have reported here from the local paper, UGI had a meeting, an editorial board meeting with the local paper, and in that article, UGI stated twice that there is absolutely no evidence whatsoever that property values are harmed by pipelines, and they also said that the insurance doesn't go up, I believe, as well. And that really surprised me. And so tonight I've gotten another surprise to hear you say that apparently that does happen, that your property value does decline when you have a pipeline on your property.
Their statements then are entirely consistent with everything I've said here. They'll make statements, whether it's an editorial board, or the president of the company, or the land agent, do anything and everything they can to deceive people, to make them give up their property rights and take away their constitutional protections of the value of the property.
Okay, so it's not true that your property is not harmed by a pipeline?
Think of it as practical terms, as it would say a board of view, than the initial trial level. I've got, my nice, farm here. Let's say I'm this bingo board here, and I've got a home here on property number 9, and the pipeline's coming through 5, 11, and 17 coming through here. Well, that's a pipeline with the risk of explosion that would kill me and incinerate, all my family and my animals, and entirely destroy the land and any property. Now, that's not likely to happen, but it certainly could. And the market takes into account those kind of markets. Think of you as being a buyer. Would you want to buy that property with a pipeline through it for the same price as one without a pipeline? No, it makes no sense.
Well,
This is
I
a
asked-
significant intrusion of property rights.
I asked one of the gentlemen when we had a meeting with Barry Wood that question, if that would bother him, that if it was on a property pipeline, one that he'd have no problem because it was safe.
Yeah, well, I wonder if he does live on a pipeline. I would kind of doubt it. He would know some of the risk and dangers. It's a propaganda campaign is what it is. They're working to deceive you. And unfortunately, they do deceive a lot of people, and people sign off, and they might get a meaningful amount of money, let's say $15,000 that they didn't have before. And the pipeline is going to be buried. But yet, their properties maybe been harmed $50,000 or $60,000. That's where the harm is, and the deceit allows this company to get away with people that don't stand up for their rights. It's across the board. This is a systematic organizational thing done from top to bottom, and they're consistent with their efforts that they'd rather not pay you, they'd rather make profit for the company. And capitalism is great, but constitutional rights are greater. Yes, sir.
Yeah, hey, when I come here tonight, I did what I was going to hear, but I like what you hear because this is a national conversation and actually outside the United States. And what you're saying tonight is exactly what I've been doing for the last couple of years.
Right.
They use tactics and they use issues, and I'm going to kind of follow up with the UBI track record. Talking guys who know that they're used to go to Sullivan County, Baylor County, their property values have reduced 30 to 40%. Some people have to walk away from their home because of a lot of situation. They wait on releases, and the gas line explosions doesn't happen every day, but they happen more than people realize because sometimes they don't get publicized.
Right.
And it's the media. I know this stuff, and it's the low water cancellation finally sitting out and announced what the water cancellation So if you are considering this, what do you say? But well, I'm seeing the last 2 years, research this. And literally said it really good. So be very careful. We certainly have to know, what the 5,000 people have witnessed over.
And it's not just this pipeline or this pipeline company or Pennsylvania.
Right.
We contrast Pennsylvania with New York State with its moratorium on fracking, and there's different arguments on either side of the state line for both positions, and a lot of discussion, as well there should be. There have been a number of people in the northern tier that have gotten a lot of money, that they're pretty happy. There's very valuable resources. The law covering the development of them really is basically law that covers our nation. Our laws are defined, if you have common problems or need common protections across the state, often we would have federal law. So we have the federal government that regulates the interstate pipelines. And this pipeline, while it's all within Pennsylvania, they're applying to FERC. It would tie in to other pipelines across state lines. So it's involved in the interstate commerce. And these problems aren't just in Pennsylvania. As I go to the National Eminent Domain Conference every year and speak to my colleagues of the Owners Council, we have the same sorts of problems in many different states. Probably more acute here in Pennsylvania, more frequent with the boom that we're having in the state. It's still ongoing, and a lot of pipeline activity is going to proceed through the rest of my career and after that, I believe. Yes, again, same sort of this.
This has the opportunity, but the pipeline is for work. And how they finally decide how to do this development. It has the potential of doing right gas companies, another line doing right gas companies work and going to the next person.
But we know what certain things are proposed, and you can look at FERC filings. I can't tell you where UGI is in the FERC application process. But at some point, there'll be a FERC docket number. You'll be able to check and see on the status of things. I think you could do that now. And that'll give you updates on the current project. Well, they're right behind that could well be the new project of going the next step or the next level. That isn't necessarily something that they want to make public at this point in time. So yeah, that could be possible. And these are dramatic changes in Pennsylvania. I grew up in Scranton, northeast Pennsylvania, the beautiful mountainsides and lakes up there. Came back to Pennsylvania from New Jersey after I finished law school. I was happy to come back to the beauty of Pennsylvania, but we're being scarred. My travels to Washington County, particularly Southwest, show that somewhat ahead of the curve compared to around here of the extent of the pipelines and the damages and the harm to the environment out there. But it's massive and very powerful. It's affecting your property rights. Get your protection for your damages. In the back, yes.
If you have an agreement, which I think you're quite happy to get at some point, and there is an explosion.
I'm sorry, let me get a little closer here.
If you have an agreement, and I assume that you're quite happy that and there is an explosion, do you still have the right to sue for them or no?
Well,
And what about subsequent owners? I mean, they could realize some that.
probably your heirs would have the right to sue. If it's that kind of an explosion, this is a very explosive, powerful, volatile substance. And if it's close to your home, you would expect there to be loss of life. You should be protected as a property owner in the event of an explosion. Assuming the property owner does not engage in any sort of negligence, you're not digging for a new house or you hit the pipeline with a farm tractor or something. As long as the property owner wasn't negligent or doing something outside the normal risk or duty of care, then it's a pipeline company that has the property, that property right of an easement, and is operating a dangerous substance. And they certainly should be and would be subject to extensive lawsuits in that situation. Or loss of life and loss of property. If there is such an explosion, we've got to expect it to be a large, devastating impact. Now, generally it wouldn't be all along the whole length of the pipeline, but for that area where the pipeline is loaded, there would be danger, a lot of danger and a lot of harm. And it might well take a while before the gas is shut off. The event from yesterday took about 3 hours, I believe, for them to shut off the flow through the pipeline. Yes?
Could you please explain what, behind the company name, the letters LLC stand for?
Limited Liability Corporation.
Right.
And those would be corporations that are established under laws of Pennsylvania or other states that it's nothing unusual or strange about it, but what corporations do is limit liability. That you would have a right to sue that company, but you might not be able to get to the assets of the parent company or the assets of some of the owners. The corporation entity often provides some protection from losses beyond, at least limited to the assets of that corporation. So an LLC would be a limited liability corporation. Yes, sir, with it.
Suppose you had an agreement with the developer of the pipeline. You said that the party agreement to work, things were required to get, I guess, legal information. Whose firm is that? Whether or not you're satisfied with the facility.
Okay, the question is about the representation that they would restore the property to the prior condition. And the landowners will tell you they'll restore it, it will be exactly the same thing, it'll be even better, but often that's not the case. What controls are the property rights that are in the agreement. So in an easement terminology, we might have restoring the property in the same condition or better than before. Some of this is going to go through farmland. Well, we might want to have provisions for them to bury a pipeline, say 4 feet instead of 3 feet. And generally they would comply with that. we might have them do what's referred to as a double ditch methodology, where they dig over the topsoil and save that, separate that out, and then do another digging of the bottom soil, put in a pipeline, and then reverse that scenario so you have the topsoil back. But the foreign soil is often very harmed by that process. So rarely does it get back to the way it was. There are some federal requirements that do suggest that they return it, and I don't know the exact terminology, it's reasonably practical or something along those lines. So they've got to try to return it to its condition before. Now they don't need to return it, plant trees on it, and they probably have provisions to prevent trees on it, things like that. But that's something that we could look at for a particular owner as terminology in the easement agreement, that maybe in addition to the federal requirement, that maybe would have some teeth in an easement agreement. But it's hard to do. After pipeline company is through and done their work, it's pretty tough to get them to come back and don't do anything after that. They're off another pipeline project in 4 states away. Yes.
You have 3 beats and standing through the big one, so to speak. It's
Okay.
a farm.
Okay.
But with the campground, very, very close, they're saying they're not touching that campground. But I know it's within that 500 feet, and you'll have East Coast, so they only can walk around.
Okay.
For one thing.
Okay, I got it. The question is really a property with 3 gates, 3 different parcels, and they're probably right next to each other.
Oh, yeah.
And maybe she used one as farm, the big one, and there's a campground nearby. Well, that campground would probably be hurt by this coming through, certainly maybe within 500 feet, and it's going to be farmed. What does the law do with that? The law in Pennsylvania applies what's called a unity of use doctrine. And I'm getting a little technical here, but it's what answers the question. If there are properties that are in substantially identical ownership that are used for the same purpose, then those parcels should be treated as if they were together as one. Now, your property, we'd have to take a look at that, because you have campground use and farm use, so it might be debatable whether it's the same use or not.
And then, yeah, there's one farm,
Sure.
waiting green, campgrounds, business, kind of purposes.
Right.
Then there's another part that's all the marriages, it's small.
Okay. We'd have to look at some, that might be a little fact specific, but that's the general doctrine. That might apply to other people too, that's why I wanted to go into it. Often you might have a property with multiple parcels, you might have a road coming through them, you might be nearby, so that unity of use doctrine is what deals with that situation. And often it would be a larger parcel that should be considered for damages. Sometimes that question of multiple parcels implicates, I'm not sure how to pull this down low. Is that better? Eminent domain code allows for reimbursement of up to $4,000 in professional fees for attorney, appraisal, and/or engineering fees. So sometimes I've been able to define that use as 3 different parcels to get 3 different $4,000 amounts. So they would want to use that doctrine against you. I would want to use that doctrine to your favor. Yes, you have a question there? I have not seen those arbitration clauses in the agreement. An arbitration clause would be restricting you to going to an arbitration or an alternative dispute resolution process as opposed to the availability of the court process. That would be contrary, in my opinion, to your constitutional rights for just compensation and including a trial by jury of your peers for the protection of your property damages. So we don't see those cases.
I have a question. 2 years in a row, we have hearings on owners. We got a notice in our homeowners bill. 2 years in a row, I think it might come from our agent, not the company itself. It says if there was any gas infrastructure anywhere near my home, I would have to go to your provider on my energy.
Yes, I am, and unfortunately so. That does happen sometimes. Yeah, insurers, for homeowners insurance, they're in the business of, insuring for risk. They recognize the risk that we've been talking about with this blast zone. So they want to protect themselves against, that risk. Now, the way I would expect that would be play out in insurance purposes, and I previously led the perhaps the biggest defense institute of insurance defense in Pennsylvania. But the way insurance would play out, you might have, if there's an explosion and damage to your property, there could be lawsuits against the company UGI. Now, there could be a lawsuit from somebody that names you or your insurance company. Well, generally, in our American system, anybody can sue anybody. So the lawyers put in everybody on the sheet and name everybody under the sun. Well, what would commonly happen, in my expectations, would be that the homeowner and the insurance company would be dismissed from that action because they weren't at fault. It was something to do with that pipeline. It wasn't anything that the homeowner did. So that insurance company would probably not have to pay out their claims. Instead, they might have recovery from the pipeline company for the value of the home. So, well, they're making you buy when the reality is they probably would not have to pay. So one of my suggestions is when you're hearing that is that you consider other insurance companies. They don't all do that. And different companies treat that risk differently. You might be able to work with an agent that you might know or somebody that might look at your particular property and recognize that the pipeline could be quite far away and not be as dangerous to your property as another property whereby the pipeline is right close to it. Yes, in the front.
As far as you know, in the past, have there ever been, or is there a potential way to prevent a pipeline company from obtaining an illegal domain in any way? The second part of my question is, has there ever been any company or any way that they could use their right of eminent domain that they could lose?
Okay, good question. The first question is of stopping a pipeline company from trying to use eminent domain. And the answer to that is yes. I'm very happy to tell you that I did that last year. And it's one of the cases listed in the notable cases handout of Loper v. Sunoco, whereby that pipeline company, not a natural gas company, but a pipeline company, asserted that they had the power of eminent domain. And I was able to go to court and get the judge's ruling that they didn't have eminent domain. So that can be done. I don't know of it being done against a natural gas company. The Natural Gas Act does specifically give the power of eminent domain, when approved by FERC, for condemnation. Now, FERC could potentially deny this pipeline for some reason. It's not in the public interest. You didn't follow the right steps. That can happen. I don't know if it ever happened in the past, but it's possible that it would happen. I think it's probably more likely that that the property owners would win in the Atlantic Sunrise pipeline. That's a bigger pipeline, 42-inch, and there's been great opposition along the whole length of that pipeline. We're a relatively short pipeline at 35 miles, but I encourage people to contest, let your legislators know, let FERC know, do the filings, oppose it. You have a right to